Hamed Alexander, attorney and founder of Alexander Abramson, a business law firm, and the author of The Guide to Selling Your Florida Law Practice. And I'm going to talk a little bit about internal transfers, because internal transfers tend to be the most popular when it comes to attorneys. Most attorneys think they want to do an internal transfer. So we would typically advise an attorney to do an internal transfer in 3 steps. So let's say that Perry Mason is selling his firm to Saul Goodman, better call Saul, right? So what we would typically do then is have Perry would bring Saul on as what I would call a junior partner. So they bring him on at a small percentage of interest. They would become a shareholder of the PA or a member of the PLLC. And so this is kind of the test period, right, to see, is this going to work out? Does this make sense? When that happens, the first transfer of equity, right, we want to have a good shareholders agreement, because we want to be sure that if for some reason Saul doesn't work out, maybe he's not ethical, whatever the case may be, that we can get Saul out of there. And that if for whatever reason Saul can't complete the purchase, that we can still sell the firm. And those are 2 provisions that we would have in an operating agreement. We'd also have a specific written employment agreement with Saul so that we can lay out our expectations about what his production is going to be and what his compensation is going to be. Now, that initial purchase typically looks like Perry Mason taking back a note from Saul. So Perry sells Saul the stock, and Saul gives Perry a promissory note. And then Perry has a lien on those shares, so that for some reason Saul doesn't pay, Perry gets the shares back. So that's the first stage. So we operate with that for a little while until Perry feels like, hey, this really makes sense. Then we move to the second stage. And the second stage is, at this point, a situation where we're really getting to the point where the first true part of the transfer occurs. And so we would sell Saul the amount of stock necessary to get him to, 49%. We don't want Saul to get to 50%, and we certainly don't want Saul to get to a majority ownership position in the company. And then at that point, we can finance that in 2 ways. Either Perry can take back a note like he did last time, or if Saul owns 10% or more of the stock and has owned that for a period of 1 year to 2 years, then sometimes we can get the SBA to finance part of that transaction because it looks like a partner buyout transaction. And so the SBA will treat Saul as a partner if he's acted in that fashion and been in that capacity for that period of time. And then we move to the third stage. So at the third stage, Saul buys the rest of the firm. And we're typically going to want this to be financed through a bank or through an SBA guaranteed loan. And at that point, then, Perry is leaving the practice. He might stay on as of counsel for a period of time, depending on how fast we went through stages 1, 2, and 3. But oftentimes, he'll just go off and retire at that point in time.